In this episode, we move into a part of incident handling that can feel formal and uncomfortable to new analysts, yet it often becomes one of the most important decisions an organization makes after a serious security event. Regulatory and law enforcement reporting sits at the point where technical response meets outside accountability, because a company may need to explain an incident not only to internal leaders and affected customers, but also to authorities who oversee legal obligations or investigate criminal activity. For a beginner, it helps to understand that this reporting is not just paperwork added after the real work is done. It can shape how the incident is documented, how evidence is preserved, how timelines are managed, and how the organization is judged long after containment is complete. A company that handles outside reporting poorly may create legal exposure, damage trust, or interfere with an investigation even if the technical response was competent. A company that handles it well is much more likely to show discipline, credibility, and responsibility under pressure. Before we continue, a quick note. This audio course is a companion to our course companion books. The first book is about the exam and provides detailed information on how to pass it best. The second book is a Kindle-only ebook that contains 1,000 flashcards that can be used on your mobile device or Kindle. Check them both out at cyberauthor.me in the Bare Metal Study Guide series. At the most basic level, regulatory reporting and law enforcement reporting are related but not identical. Regulatory reporting is about informing the appropriate governing or supervisory body that an incident has occurred when the event meets a threshold set by law, regulation, contract, or formal oversight expectations. Law enforcement reporting is about notifying authorities who investigate crimes so they can evaluate whether criminal activity took place and whether they can help the organization understand, contain, or pursue the people responsible. These two paths sometimes happen together, but they serve different purposes and are shaped by different questions. A regulator may care about whether sensitive information was exposed, whether required protections were in place, and whether the organization met notification timelines. A law enforcement agency may care about threat actor behavior, evidence preservation, patterns across victims, and whether the incident connects to a broader campaign that extends beyond one company. One reason this topic matters so much is that organizations do not get to decide outside reporting based only on preference or reputation concerns. In many environments, reporting obligations are shaped by industry rules, privacy requirements, public sector duties, contractual commitments, and the jurisdictions in which the organization operates or where affected individuals live. That means a company may have different reporting expectations depending on the type of data involved, the kind of service affected, and the location of customers, employees, or systems touched by the incident. A healthcare organization, a financial institution, a government contractor, and an online retailer may all experience security incidents, but the reporting obligations around those incidents can look very different. For a beginner, the key lesson is that outside reporting is rarely a simple yes or no decision made by the technical team alone. It usually depends on formal rules that must be interpreted carefully, which is why security teams work closely with legal, compliance, privacy, and executive stakeholders when deciding what must be reported, to whom, and by when. Not every suspicious event or confirmed incident automatically becomes a reportable matter, and this is where judgment becomes especially important. Organizations usually need to ask whether the incident affected protected data, critical services, regulated systems, financial transactions, public safety, or other areas that create external reporting duties. They also need to assess whether the incident caused actual harm, created a significant likelihood of harm, or reached a level of severity defined by outside rules even if full impact is still being investigated. A small malware event on an isolated test machine may be serious internally, but may not trigger outside reporting. A compromise affecting customer records, payment information, core operational services, or sensitive internal data may move much more quickly into reportable territory. For new learners, the important mindset is that reporting thresholds are usually tied to consequence, exposure, and obligation rather than to how dramatic the technical details sound. A flashy but contained event may be less reportable than a quieter issue that touches regulated information or essential services. Timing is one of the hardest parts of regulatory and law enforcement reporting because incidents rarely present their full story at the beginning. In the first hours of an investigation, the organization may know that something bad happened while still lacking confidence about the method, the scope, the affected population, or the full operational consequences. Waiting too long to report can create legal and reputational problems if deadlines are missed or authorities believe the organization delayed unreasonably. Reporting too quickly without enough care can create different problems, especially if the report contains inaccurate statements, premature conclusions, or facts that later need substantial correction. Good reporting discipline handles this by distinguishing between what is known, what is suspected, and what is still under investigation at the time of the notification. For a beginner, this is a very practical lesson. Outside reporting does not require perfect certainty, but it does require controlled timing and careful language so the organization can meet its duties without pretending to know more than the investigation actually supports. That balance between speed and accuracy is one reason evidence preservation matters so much before and during outside reporting. If an organization may need to notify a regulator or involve law enforcement, it has to be able to explain why it believes the incident occurred, what systems or data appear to be affected, what actions have already been taken, and how those conclusions were reached. That means security teams must preserve logs, alerts, forensic artifacts, timelines, decision notes, and records of containment activity in a disciplined way rather than relying on memory or scattered chat history. When law enforcement becomes involved, evidence handling can become even more important because investigators may want to understand the sequence of events, the technical indicators, and whether collected information can support further analysis of the attackers. For beginners, the lesson is that reporting is not just about sending a notice. It depends on the quality of the facts behind that notice. An organization that cannot support its own timeline or explain the basis for its conclusions will struggle both with regulators who expect accountability and with investigators who need reliable information. Because the stakes can be high, outside reporting is almost never the job of one person writing one message alone. Security teams usually provide the technical understanding of the incident, but legal teams help interpret obligations. Privacy teams may assess the sensitivity of affected data. Compliance staff may identify formal reporting pathways. Leadership may approve strategy and tone, and communications teams may prepare language for aligned external messaging. If law enforcement is being contacted, executives and counsel may also weigh the benefits and risks of that step, especially if it could affect operational decisions, public statements, or negotiations with a threat actor in an extortion scenario. What matters most is coordination. A regulator should not receive one version of the event while leadership is telling a different story internally and customer communications are using yet another explanation. For a new learner, this is a clear example of why incident response is organizational rather than purely technical. Effective reporting depends on multiple parts of the business working from the same current understanding of the event and the same disciplined approach to what will be communicated outside the company. A strong regulatory report usually explains the nature of the incident, when it was discovered, what categories of systems or data appear to be involved, what the organization has done so far, and what remains under investigation. It should help the reader understand the event without forcing them to guess at basic facts such as whether the issue was a data exposure, service disruption, unauthorized access event, or something else entirely. At the same time, the report should avoid overstating certainty. If the organization does not yet know the final number of affected records or the complete root cause, the report should say that clearly instead of filling the gap with assumptions. Regulators generally care about both substance and discipline. They want to know whether the organization understood the seriousness of the event, moved with reasonable speed, preserved enough information to support its statements, and continued the investigation responsibly after the initial notice was sent. For a beginner, the central point is that a regulatory report is not just a confession of trouble. It is a formal explanation of what the organization knows, how it is responding, and how it is meeting its obligations while the incident unfolds. A law enforcement report serves a different purpose, so the content often leans more heavily toward the details that could help investigators understand potential criminal activity. That may include observed attacker behavior, known indicators, suspected points of entry, ransom or extortion communications, impacted systems, evidence of fraud, and the timeline of suspicious actions that led the organization to believe a crime occurred. Law enforcement may also care about whether similar activity was seen elsewhere in the organization, whether funds were demanded or transferred, whether the threat actor contacted employees directly, and whether technical artifacts suggest a known campaign or group. The goal is not to overwhelm investigators with raw data that has never been organized. The goal is to provide enough reliable information that they can judge the situation, advise on next steps, and potentially connect the case to broader criminal patterns. For beginners, this shows that reporting to law enforcement is not simply telling police that the company had a cyber problem. It is providing a structured account of suspicious or malicious activity that may be part of a prosecutable or intelligence-relevant event. Deciding whether to involve law enforcement can be difficult, because the benefits are real, but the choice can also affect how the organization manages the incident. In some cases, law enforcement may provide threat intelligence, guidance on active campaigns, help with extortion situations, or coordination across multiple victims facing the same attackers. In other cases, the organization may worry about operational disruption, evidence preservation requirements, public attention, or uncertainty about how much help authorities can provide in the specific situation. There is no single rule that fits every incident, but some events make law enforcement involvement much more likely to be appropriate, especially those involving large-scale intrusion, theft, ransomware, fraud, threats to safety, or conduct that clearly appears criminal rather than accidental. For a beginner, the important mindset is that law enforcement reporting should not be viewed as a dramatic last resort or a symbolic gesture. It is a practical decision tied to the nature of the incident, the possible value of external investigative support, and the organization's broader duty to respond responsibly when malicious actors may still be active or may threaten others beyond the company itself. A number of common mistakes can weaken regulatory and law enforcement reporting even when the organization means well. One mistake is delaying too long because leadership hopes the issue will become smaller or clearer before anyone outside has to be told. Another is reporting too casually with incomplete review, which can lead to inconsistent facts, confusing timelines, or statements that later create credibility problems. Some organizations fail to separate confirmed facts from working theories, which makes their reports sound more certain than the evidence supports. Others forget that different outside audiences need different details and end up sending language that is technically dense but practically unhelpful. There is also the problem of poor internal alignment, where security, legal, leadership, and communications teams do not share the same current view of the incident before reporting begins. For new learners, these mistakes are important to recognize because they show that good outside reporting is not just about good intentions. It is about disciplined coordination, careful drafting, and respect for the fact that the organization may be judged heavily on the clarity and credibility of what it reports under pressure. Outside reporting is also rarely finished after the first notice is sent. Regulators may ask follow-up questions, request additional detail, expect updated impact assessments, or require final documentation once the investigation is more complete. Law enforcement may request preserved evidence, additional technical artifacts, copies of extortion messages, financial details in fraud cases, or contact with investigators who can walk through what the organization observed firsthand. This means the first report is often the beginning of an ongoing relationship rather than the end of the obligation. Good incident teams plan for that reality by maintaining clear documentation, updating internal timelines, and making sure responsibilities remain assigned after the early crisis phase passes. For a beginner, this is an especially useful insight because it keeps reporting from feeling like a one-time administrative hurdle. In reality, outside reporting is part of the longer life cycle of the incident, and the quality of follow-up can matter just as much as the quality of the initial notification when authorities assess whether the organization handled the matter with seriousness and care. Imagine a company that provides cloud-based payroll services discovers unauthorized access to a platform containing employee records and direct deposit information. The security team quickly contains the apparent intrusion, but leadership soon realizes the event may affect clients across multiple regions and may involve regulated personal and financial data. A disciplined response would not stop at internal containment. The organization would work through legal and compliance teams to determine which regulators must be notified, what timelines apply, and how early notices should describe the known facts without overstating scope before the investigation is complete. If signs of criminal activity were clear, the company might also contact law enforcement with the relevant technical and operational details, especially if fraud, extortion, or broader attacker activity appeared possible. As the investigation developed, the company would continue refining its understanding of affected records, documenting response steps, and providing updates where required. That kind of coordinated reporting does not remove the seriousness of the incident, but it makes the organization far more likely to be seen as responsible, organized, and credible by the authorities now watching how it responds. By the end of this discussion, the most important takeaway is that regulatory and law enforcement reporting is not a side task added after an incident is already under control. It is a core part of how organizations meet obligations, preserve trust, support investigations, and show that they can respond to serious cyber events with maturity rather than confusion. Regulatory reporting is about satisfying formal duties to outside authorities who oversee protected data, essential services, or industry-specific expectations. Law enforcement reporting is about helping authorities understand and possibly pursue malicious activity that may reach far beyond one victim organization. Both depend on timing, evidence, coordination, careful language, and a clear separation between what is known and what is still being investigated. For a new CySA Plus learner, the mindset to keep is simple but important. A serious incident often creates responsibilities outside the technical team, and strong reporting is one of the ways a security program proves that it understands not only how to detect and contain a problem, but also how to face outside scrutiny with discipline, accuracy, and accountability.
Thanks for listening. For more audio courses, daily newsletters, and more, please visit baremetalcyber.com.